Welcome, everyone. I'm Leslie Sowers, a partner in Husch Blackwell's Consumer Finance Services Group. And I want to thank you all for joining us today for the webinar on higher education and consumer finance, what institutions and financiers of higher education need to know. Before we begin, we have a few housekeeping items to go over. There are multiple application icons at the bottom of your audience console for your use during this webcast. Please submit any questions you have during the webcast via the question box, and we'll try to answer those during the program, but if a fuller answer is needed or we run out of time, we may have to answer later via email. A PDF of the presentation is available in the program materials folder. The program has been approved for complimentary continuing legal education. Live attendees may report their hours by clicking the CEU icon at the bottom of the screen, and a certificate of attendance will be emailed to you along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our brief survey. We use your responses to plan future programs relevant to your needs. So this is very important to us if you can do so. Today, presenting with me today is Annie Cartwright and Abby Felter. Annie is a partner in our education group, joining us from our Kansas City office today. She focuses her practice around student funding matters, including Title IV of federal student aid and related obligations like non-discrimination, accreditation, mergers and acquisition changes of control, drug and alcohol, and scholarship concerns, and also issues unique to academic medicine and healthcare education, both topics relevant to our discussion today. Abby is also in our education group, but also in our consumer finance group like me. Abby devotes much of her practice to the higher education industry, helping colleges and universities navigate complex regulatory matters, particularly with respect to Title IV eligibility and compliance. Alongside her practice, Abby advises clients on regulatory compliance matters in the consumer financial services space. Again, I'm Leslie Sowers out of our Washington, D.C. office. I focus my practice on advising both federal and state regulatory matters related to consumer financial services and products, including, of course, student loans and other types of financing arrangements. This is all for our housekeeping items, so let's get started with our program. So today we're going to, as you'll see here is our agenda, we're going to discuss what we refer to right now as the hot topics of where the three of our practice groups, practice areas really combine. The education and consumer finance teams intersect on these topics and have been the focus of increased regulatory scrutiny. Not surprisingly, that we also have been receiving numerous questions in these areas as well. We have a range of audience members that we're seeing on this webcast, and it includes individuals with a variety of roles and depths of knowledge on education, consumer finance matters. So we're aiming to strike a middle ground and touch on numerous important topics, but this is a complimentary CLE, and so we've attempted to cover content that will be relevant to all of you and introduce you to these compliance considerations at a high level. It's these are all pretty complex facts-dependent situations, but we hope that each of you would leave with some pieces of new and helpful information, and we're happy to discuss additional background or higher level concepts with you at another time. So with that, we'll get started, and Abby, I'll turn it over to you to kick things off with institutional payment plans.
Thank you, Leslie, and very happy to be here today. So just to kick it off with institutional payment plans, we actually have a poll question to start off. Does your institution offer institutional payment plans? You can just click your answer and it should register. When we're talking about institutional payment plans, we're talking about like tuition payment plans where students pay for the tuition over like a period of 2, 3, 4 installments, whatever it might be. Seeing some responses coming in. Give it another couple seconds for people to get their responses. So these are our responses. Almost 70% of you say yes, your school does offer institutional payment plans. About 9% say no, or I guess it's about 10%, and 20% are not sure. These responses are not surprising. Actually, I would have thought a little bit more would say yes. The CFPB just issued a report, and in this report, one of the things they looked at were these tuition payment plans. That was the focus of the report. And they actually found that 98% of schools offer payment plans. The report was issued this month, September 14th, and it looked at 450 schools. So that's quite a few schools that are offering payment plans. And the CFPB identified risks specifically associated with these types of plans. Some of the key findings had to do with the terms and conditions and then the fees. So this slide shows some of the different fees. There's three main types of fees: enrollment and setup fees. That's basically a fee to participate in the payment plan. The report found that almost 90% of schools do charge these types of fees. 60% of participants, schools that were reviewed, charged a return payment fee. That could be like a check that bounces, or not enough funds in a checking account, something like that. And 44% charged late fees. Combining all these fees together, they found that students can face really high APRs, as high as 237%. One more type of fee that they briefly addressed, but was not necessarily the focus of it, also had to do with convenient fees or transaction fees that are associated with paying. So basically a fee for the privilege of paying with credit card or debit card. So this next slide talks about some of the risks that they identified in addition to the fees, and partially based on the fees, and then also the terms and conditions. So starting with like the contract terms, some of the contract terms that they found somewhat problematic, or at least ambiguous, had to do with waiver of consumers' legal rights, balances being accelerated, transcript withholds or holds that would limit or prohibit registration or re-enrollment, and then also provisions related to debt collection and credit reporting. They also found that the terms and conditions typically had inconsistent disclosures. So this could be either the disclosures are spread out across a variety of pages, or that the terms and conditions just aren't clear, or you wouldn't see the type of disclosure that you might think. For example, the APR might not be disclosed. So that's just some of the high-level risks that they identified. The overarching conclusion was just that, these inconsistent disclosures, inconsistent terms leave consumers oftentimes in a vulnerable position, or at least maybe not knowing all of their rights, and also that these schools aren't always complying with all of the requirements that would apply to actors that are acting like a direct lender. So I wanted to, moving on to some of the key takeaways, they're up on the screen, but I actually wanted to ask Leslie to chime in. You practice a lot in this area. Well, if you could boil it down to like 2 or 3 main points on this topic, what would you have to say to our audience?
Yeah, sure, Evie. We work with a lot of clients on these types of plans, and in my experience, many institutions are actually just surprised by the amount of information and the complexity of the different things that we need to review for potential coverage of what laws do apply or may apply, and then once we've gotten that scope, the potentially applicable requirements that might be involved in these, with respect to each transaction. Specifically, we would want to look whether such activity might trigger coverage as a creditor or a servicer under federal or state law. These are highly fact specific, and just because you might be not covered by TILA, you could be covered by a particular state law, lending law or servicing law. And these vary widely, but based on what the terms of the plan are, and in the states in which they're offered, among other things. We've also you reviewed these kind of plans to make that determination and assisted in preparing and reviewing the various materials if they need disclosures or to put in the right language or to take out the wrong language in different agreements. And just to confirm that maybe if there are any licensing or notification filings required under state law, or if there are any prohibitions or limitations on what fees may be able to be charged in connection with any of these things. It's hard to give a summary, but hopefully that gives a good idea of what's involved in reviewing these things and what things to consider. But I also wanted to mention here, as we get into the rest of this, you might be thinking about these lending laws not applying to you or servicing laws not applying to you. But what I want to remind everybody is that it's, the CFPB and the U.S. Department of Education have an MOU in place, and they share complaint data from borrowers, from student loan borrowers, and meet quarterly to discuss observations about these complaints. And they also readily share data between each other about these complaints. It's likely that student complaints related to payment plans, even if they didn't rise to the level of student loans, would also be included in these discussions and data sharing. So I just wanted to bring that up in case you thought you might be out of all of this and not covered by the CFPB. Even if so, there might be something where the Department of Education and the CFPB are having discussions about certain terms of these plans. Abby?
Thank you. Yeah, so I think that's right on point. And, just some high level takeaways would be to consider state law compliance, which could include licensure requirements, but also substantive requirements related to what your disclosures and loans might have. Consider state laws, federal laws. So you might be subject to a state law, but not the federal, or it could be the same or reverse. So basically considering whether you're subject to TILA and would be required to provide those disclosures, and then just generally practices that you would think of that are more typically associated with lending and loan products, making sure that you're considering best practices to protect students and making sure you're complying with consumer protection laws. So with that in mind, we're going to move on to a very similar topic, plan and loan servicing. So once this is basically like collecting on the payment plan. So if you have a student that signs up and they have 4 installments or whatever it would be, basically this would be like processing that payment. So we've seen a trend at the state level where states are starting to implement, or at least consider implementing, state servicing laws that would require student loan servicers to obtain a license in some instances, or there's substantive requirements to govern that process, whether it be disclosures that are required or limitations on practices that you can do while servicing a loan. So up here we have, one more point. Some of them don't apply to first-party creditors, but some do. And I'm going to take a second to explain what a first-party creditor is, even though I'm sure many of you know this. A first-party creditor would be the person or the entity that is originating the loan and servicing it. They would be a first-party creditor at a very oversimplified definition, as opposed to a third-party creditor would be if a third party is the one that is servicing a loan. For example, a school originates the payment plan and then outsources servicing to a third party. So some of these state laws don't apply to first-party creditors, but some do. So I've included some example of triggers of these state servicing laws. And so if you read through this, I'm not going to go word for word, but if you read through these triggers, you could see how a school that's issuing a payment plan and processing payments on a payment plan could be captured in this. So another thing you would want to look for in this state law is whether there's an exemption specifically for schools, which we have seen in some states. Some other high-level considerations for servicing payment plans have to do with basically the payment process. EFTA, the Electronic Funds Transfer Act, and Regulation E have to do with electronic fund transfer. So basically like an ACH withdrawal, if it's occurring at a regular interval, things like that. You just have to consider whether or not you need certain types of consent to process those payments. Moving on to that same topic, payment processing, I briefly mentioned the convenience fees, like basically a fee for paying, for the privilege of paying. You want to keep those in mind. General information sharing, and that just goes back to data, protecting students' data and student information, consumer information. Things like GLBA might apply. And then collection accounts and default and credit reporting, something that I think is really hard to distinguish. It can be between the line between servicing and debt collection. So this is actually a good transition to our next topic, which is debt collection. But you do want to just keep in mind basically credit reporting and different things that are commonplace with servicing and debt collection. So moving on to debt collection, the first thing we're going to talk about today is for debt collection is UDAP, unfair, deceptive, or abusive acts and practices. This is kind of like I don't want to say catch-all law, but it's a very broad law that's targeted at protecting consumers who have received financial products, basically protecting them from unfair, deceptive, or abusive acts or practices. The CFPB has rulemaking authority, but both CFPB and FTC have oversight on this, and we might get into that a little bit more in a second, but I wanted to move on to this next slide, which has the elements of each one. So unfair, deceptive, abusive. If you want to go through all of these, for time's sake, we have so much information to get through today. I don't want to read word for word, but I want you guys to have that information available. The bottom line for this is that sometimes no harm is needed for an act to be considered unfair or deceptive or abusive. The other thing is that basically this is a federal prohibition against UDAPs. In state law, equivalents often will mirror this. So these UDAPs combined with the many state laws give regulators, states attorney generals, private litigants the opportunity to challenge expressly prohibited or permitted and compliant practices by attacking the process and method that companies are doing to offer these credit and voluntary products. So basically, it's not necessarily about the act itself, it's about the method or process. So just something to keep in mind. Leslie, I know you have a lot of experience in this area. Are there any key points you want to point out?
Yeah, I think one thing that some clients are surprised to hear is UDAP with the extra A is new, but what isn't new is UDAP without the A. So unfair or deceptive acts or practices. The FTC has had authority in that area for quite a while, and as Abby already mentioned, most of the states also have similar authority and laws in each of their states. So this looking at unfair and deceptive in any context that would result, that's related to commerce or transactions with consumers would be subject to this type of scrutiny under both federal and state law, even if you aren't covered by, even if it isn't a financial product or service that the CFPB would be reviewing. The CFPB obviously has the abusive piece to this as well. The CFPB and the FTC coordinate their efforts quite a bit. And then I know at least California has also decided to adopt abusive into their UDAP law as well. So this is an area where a lot of people can get tripped up just because it is a little bit amorphous, if you will, kind of know it if you see it kind of situation, as opposed to black and white rules. So I think Annie, or are we back to Abby? Sorry.
I think we're going to go back to wrap up debt collection. We're also going to briefly talk about FDCPA. The FDCPA, Fair Debt Collection Practices Act, basically targets the debt collection process. It is similar to UDAP in the sense that it's going to protect consumers for the processes associated with these financial products and services. You can see the definition of debt and debt collector. I want to note that FDCPA has an exception where it doesn't apply to first-party creditors. And with the caveat that even though FDCPA doesn't expressly apply to first-party creditors, there are two very specific instances where an FDCPA standard would be applied to a first-party creditor. This would include vendor oversight responsibilities. Basically, if you engage a third-party debt collector, even if you're a first-party creditor, you have to oversee the process and make sure they're complying with applicable federal and state law, which includes FDCPA. And then also through incorporation through other laws. There's two main ones that come to mind. We have UDAP, which we just talked about. So even if you're not subject to FDCPA, if you're subject to UDAP, we've seen a trend where the UDAP standard is mirroring the FDCPA standard. So that can be a little bit confusing, but basically we generally recommend even first-party creditors to comply with FDCPA, or at a very minimum, make informed decisions when they are deviating from the FDCPA and making sure that they're aware of this trend that's going on. And then same with state laws. State laws, there's many FDCPA state laws, and oftentimes that state law is actually mirroring the federal law. And for example, I know Texas and I think California apply to first-party creditors. I'm sure there are others. So just keep that in mind. These are the key FDCPA provisions. I would say communication and connection with the debt is one of the really big ones, and it can be complicated. Basically, what you can say, when you can say it, and who you can say it to about the debt, and then just generally kind of UDAP concerns, making sure you're protecting consumers. Last thing on debt collection, transcript withholding is a very hot topic right now. We've seen a trend at the state level where they're either limiting or prohibiting transcript withholding practices. I think there's about 20 that have at least considered. Many of those have implemented it. So we're happy to talk to you about your specific state, and we can let you know if there's a state law applicable. The CFPB has said that transcript withholding is a violation of UDAP. So just keep that in mind. And then the Department of Education has also criticized this practice. Moving on to tuition discounts. I think this is Annie.
It is me. Thanks, Abby and Leslie. When we talk about tuition discounts, that can mean a number of things. It can be what we commonly refer to as institutional scholarships, which is essentially a scholarship offered by the institution based on merit or some other status. And institutions may want to offer some other types of discounts, often as enrollment incentives. There are definitely ways to offer some of these discounts, but it really is worth considering some various parameters. And the key one that we get questions about is the statement by the Department of Education in the Federal Student Aid Handbook that recipients of Title IV federal student aid may not be assessed charges higher than those charged to students who are not recipients of federal aid. We note that the statement in the handbook doesn't have a citation, unlike many other citations in the handbook, and we haven't identified a department regulation that requires this, although I think many of us can get behind the policy idea, maybe other federal regulatory idea, that students shouldn't experience discrimination in terms of what they're charged simply because they're relying on federal student aid. And from this idea, the department extrapolates that schools shouldn't provide discounts to students who pay early. And the reason for that is that federal student aid often isn't available to students until a couple of weeks after classes start, and students shouldn't be penalized simply because they're relying on federal student aid by not being eligible for the discount because they can't pay early. Interestingly, in the past couple of years, there's been a case in the news, and the news does not always report things accurately, and there's limited information available about this online. But with that qualification, it was a matter involving Eastern Gateway Community College and the Department of Education. And there, it appears that Eastern Gateway was offering what we call a last dollar institutional scholarship to students. So first it was applying federal student aid, apparently, and then it was making up for the rest of the student's tuition with an institutional scholarship, or what a lot of schools would very commonly treat as, and a number of schools commonly use as institutional scholarships. And the department in that matter seemed to be saying that this was improper because effectively federal student aid students who were paying with federal dollars were getting charged more than students who didn't receive federal student aid. For the most part, any scholarship has to be capped at what's called the student's cost of attendance. That's essentially their budget for school expenses. So you can't give more, in almost all cases, more aid than a student's cost of attendance. So if a student was receiving federal student aid, the school had to cap its institutional scholarships at that cost of attendance amount. We know that last dollar institutional scholarships are relatively common, and we very much hope that the department will issue some clear guidance around whether and how institutions should be offering institutional scholarships, which, just like federal student aid, are critical to a lot of students' ability to attend college. How about some other types of discounts? The general rule is not just about discounting, but about whether different rates of tuition for the same program of study are charged. So you can charge more for medical school than you charge for, say, an art history degree. But within the same program of study, you should not be charging Title IV federal student aid recipients more than you're charging other students. And therefore, offering a discount in kind, such as free classes or added support services to students who aren't paying with federal student aid, would seem to violate this prohibition on charging federal student aid students more, as would a cash discount. So discriminating against students based on paying for their tuition and fees with federal student aid versus paying with cash. Some schools might want to offer, say, $500 off for early enrollment. And from a Title IV federal student aid perspective, the hook there seems to be enrollment or registration for classes versus payment for that enrollment or registration. And so this early registration deadline or early registration discount seems to be low risk in terms of the Department of Education's rules. And we will also consider whether an early enrollment discount may be appropriate under the TILA rules later. And Leslie will do that because she knows far more about TILA than I do. Let's look at some other rules around when and how students can be charged various fees. Some schools want to charge overtime fees to students if they're taking more time to complete than a standard time frame. And note that Title IV federal student aid, as well as VA and military funding rules, don't allow, or they suggest that they don't allow, that those federal funds be used for overtime charges. So be careful with your financial aid office as to paying those overtime charges with federal funds. Same goes for finance charges. Institutions may not use federal student aid funds to pay finance charges or fees incurred because a student uses a financing payment method offered by the school, like a payment plan. There are some new concerns about when and how these fees are charged, but we definitely don't recommend applying federal student aid monies to fund them. How about test prep class costs? That comes into play often in our professional programs. Near and dear to our hearts are test prep courses for bar exam fees. Those test prep fees may only be included if they are a degree completion requirement for the students. So if they don't have to complete that test prep course as part of their degree requirements, that test prep course should not be included in the student's cost of attendance. Again, their budget for how much money they can get for attending school. However, effective this very academic year, there is a new rule that the cost of obtaining a professional license certification or first professional credential is a required component of the student's cost of attendance. So that would be things like not test prep unless it's required as part of their degree program, but the cost of taking a bar exam fee where a bar exam passage is required for licensure in the area in which the student is studying. And then finally, institutions may not impose a penalty on a student for either the school delaying disbursement of scholarship or federal student aid or other federal aid funds, or if there's a delay on the federal side. So let's say the VA or the Department of Defense or federal student aid delays disbursement. we should not be charging students additional fees based on that. And now I'm going to hand it over to Leslie, who is our Truth in Lending Act guru.
Well, thanks, Annie. As we've already touched on today, education financial arrangements should be reviewed to determine if the arrangement might be considered credit or otherwise covered for purposes of federal and state consumer financial laws. One of the more onerous ones of the federal laws is the Truth in Lending Act, or also known as TILA. It has strict disclosure requirements for advertising forms of credit and or extending credit to consumers. It's enforced by the CFPB, who's also in charge of implementing its regulation, which is Regulation Z there on the slide. In terms of credit disclosure, TILA creates the minimum requirements, and then states and other regulatory bodies may require additional requirements or term restrictions, as long as those do not conflict with TILA or other federal laws. So both may be in play for you. So when does TILA apply? So first, we have to remember TILA has its own coverage, and it covers credit. It defines credit differently than some state laws do, but its definition is the right to defer payment of debt or to incur debt or defer its payment. That's pretty broad, but they also limit it to say that credit must be either subject to a finance charge or payable by written agreement in more than 4 installments. So many of your payment plans that we talked about earlier that may not have if they do not have a finance charge and they're payable in 3 or 4 installments, would likely not fall under TILA. Now, they might fall under something else, but they won't fall under TILA. But then there's the private education loan section, and TILA has special disclosure requirements that apply to loans that fall within that definition. And that is credit that is extended to a consumer for post-secondary educational expenses. And it includes loans provided by the educational institution that the student attends. Title IV loans are exempt from these requirements. So these are all private educational loans. These special disclosure requirements do not apply to an extension of credit by the covered educational institution if the term of the extension of credit is 90 days or less, or no interest rate will be applied to the credit balance and the term of the extension of credit is 1 year or less. And that's regardless of whether the payment is payable in more, or the credit is payable in more than 4 installments. Even if it meets that exception, where the covered educational institution exception, it may still be covered by TILA's standard disclosure requirements. Most people recognize the TILA box, the TIL box at the top of most of their credits and credit card statements and things like that. Those are your standard TILA disclosure requirements, and certain loans that fall within the exception, the covered education institution exception, may be required to follow those. As discussed earlier, if you get out of all of this, you don't forget that there's still state laws, and that there's also the UDAP under federal and state law, and they're going to all require clear and conspicuous disclosure of all material terms of any sort of arrangement. You can always use TILA and your state disclosure laws as kind of guideposts of knowing what those regulators might view as an effective disclosure and timely disclosure. Even if you're not required to comply with those, it's a great way to find out what a best practice is. And so I want to turn over to what is required of the private education loan disclosures in particular. There are 3 main ones. One is given at or with a application or solicitation for the loan. It's not individualized to any particular student, but has the terms or range of terms and rates available for the loan. The second one is given at the time the person approves the student for the loan. This is individualized to that student in terms of what rates and terms will apply. The student has to be given 30 days after receiving this disclosure to accept the loan. In most cases, we don't see them waiting that long to do so, but it is required that you allow them to. And you can also allow them more time. The third is the final disclosure, and this disclosure is typically provided with the loan agreement or a promissory note for the student to sign. After this final disclosure is given, the student signs the note, they still are permitted to cancel the loan without penalty until midnight, the third business day following the date that they received the disclosure. And the lender is prohibited from dispersing loan proceeds until this waiting period is complete. And then there's this fourth form that is kind of a hybrid between consumer finance and education. It's the self-certification form, but it is required under TILA as well. And so Abby, how do you recommend that schools and student lenders handle that form?
Yeah, so the self-certification form is, it's a set form that typically is provided by either the institution or the lender, but at a minimum, the institution has to ensure that it's provided. So what we typically recommend is that the form is provided with usually the loan approval disclosure form, and then the student can go to the school, or the school can help the student fill out the cost of attendance section. And then the form is provided back to the lender before the loan is consummated, before any funds are dispersed or anything like that.
Great, thank you. And then just quickly want to talk about discounts again. As Annie had mentioned, some of these will be prohibited in some contexts, but here, if it's not prohibited and you're charging a discount, we wanted to mention that how that interplays with finance charges under TILA. So whether a particular fee or charge imposed falls under the finance charge definition that's here on the slide is a question that lenders and us CFS attorneys struggle with regularly. And at least at first glance, some amounts like discounts would not seem to be a charge at all. However, if a student is if you're offering one student a discount for paying for cash, and another student doesn't have the benefit of that discount because they're paying with credit, then that might potentially be considered a finance charge under TILA. And then making this determination is critical, obviously for disclosure purposes if you're covered by TILA, but it's also critical for whether you're covered by TILA in the first place. As we discussed a little bit earlier, TILA governs credit transactions that are payable in more than 4 installments or that include a finance charge. So maybe you have no other charges associated with what your transaction but you do offer a discount that TILA would view as a finance charge. Then we may be in a territory you were trying to avoid. So we would need to take that into consideration when you're structuring your plans. And so I think we've pretty much already hit this, is whether a discount for cash players would be considered a finance charge. So the cost of paying tuition for the same amount of classes is higher for individuals who opt out of a payment plan. A discount for early enrollment, however, would likely not be considered a finance charge, assuming the discount is available to all students, regardless of whether the tuition is financed.
Thanks, Leslie. We are going to turn to a topic near and dear to my heart, which is employer-required training and tuition forgiveness. And it's near and dear to my heart because it is super common in the healthcare industry and healthcare education programs to have a number of scenarios that may fall within the definition of employer-driven debt or employer-driven tuition payments. The CFPB has started to pay attention to these in recent years. These scenarios may involve situations where we have employer-provided loans to attend school, usually in exchange for a promise to work for the employer for a certain amount of time after graduation, or employers offer to repay student loans. Say the student takes out federal student loans and the employer offers to repay them in exchange for a promise to work for the employer, or what the CFPB has now termed traps. To clarify, that is their word, it is not our word. And employees there agree to repay either through work or even through more direct forms of payment, employer-provided training that may be extended, highly skilled continuing education, or it might be more akin to what we typically think of as on-the-job training. These employer-provided loans and loan forgiveness are a critical way that we have in the past funded healthcare education for the much needed, highly skilled healthcare professionals in our world, including nurses and doctors. And especially at a time of workplace shortages, it may be critical to ensuring the survival of our health system going forward. So how do we do these in a compliant way? Let's look at what the CFPB's concerns were in a report it issued in July. I'm not going to go into tremendous detail here, but I will note that it is linked in a blog post, a client alert that's on our website, written by our colleague, Dan Wilkinson, and all of the speakers here today. In sum, the CFPB identified various concerns. They said employers may prevent workers from fully understanding the terms of these employer-driven debt arrangements. The CFPB found that some employers may not give employees a copy of the agreement. They may hide terms among all those papers that we sign when we're signing up for a new job, or they may unilaterally change the terms of the agreement, which I don't think any of us would appreciate. So to address this cluster of concerns, we would suggest that if you're engaged in an employer-driven debt arrangement, you make sure that workers are clearly informed of express and conspicuous and set terms, and that you give them time, just as you would any other consumer, to consider the transaction, that this isn't a high pressure transaction. The CFPB also said that the employers may abuse employees' need for a job, their sort of unequal bargaining power, in pressuring them to enter these agreements. The CFPB cited a study from the National Nurses United for the proposition that over 44% of nurses who've been working for less than 5 years have been subjected to a trap, to an employer-driven debt agreement for continuing education type training. To mitigate the concerns that we are abusing any sort of bargaining power that employees or recent graduates may have, we would suggest that employers take steps to ensure that employees understand that they have a choice here. And because employees may feel trapped in a job for want of the ability to repay funds if they quit, consider different ways that you can mitigate the impact of an employee wanting to leave a job or needing to leave a job, so that we're not in some sort of indentured servitude kind of situation. Be sure that you provide an effective off-ramp for your workers that's reasonable in light of the arrangements. And then the last bucket of concerns that the CFPB identified in its report was that employers may not be giving accurate information about the cost of debt and the benefits of incurring the debt to their employees, basically saying that this may really just be on-the-job training that we should be providing to employees for free, depending on the nature of the training. And employers should be upfront with employees about the value of the training that they're receiving in exchange for debt. So again, as with the other issues we are discussing today, be sure if you're entering these arrangements to make sure that employees know, or recent graduates know, very clearly in advance what they're agreeing to, what they will receive in exchange for their agreement to repay the debt. Be sure that you're providing reasonable disclosures and giving your employees copies of the documentation. Also, as a catch-all, be sure that you are complying with wage withholding rules and debt collection rules and appropriate record-keeping practices. for employers, consider the questions on this slide when you're drafting these arrangements. Also, for educational institutions that may be involved in these arrangements, keep in mind that you may have some obligations around preferred lending agreements. Abby and Leslie touched on those a little bit. If you have a preferred lending arrangement for a private education loan, you as an institution have certain obligations, mainly disclosure obligations, but other obligations to ensure that you're not pushing your students towards unreasonable agreements and things like that. So as you are encouraging students to enroll in these education for work agreements so that they can fund their educations, take some common sense steps to ensure you're complying with your Title IV obligations and that students are aware of what it is they are getting into. And I will hand it back over to Leslie or Abby to talk more about preferred lending arrangements.
Thank you, Annie. Yeah, so moving right into preferred lending arrangements. What is a preferred lending arrangement? It can be something like a formal contract between a school and a lender agreeing to either promote, recommend, or help facilitate this lending, student lending program. MOUs to the similar effect, informal agreements, or it can even be triggered just as simply as recommending, promoting, or endorsing a loan. This language, this italicized language, the quote is from the Department of Education's, their preamble to the final rule for these. And it just solidifies the fact that a preferred lending arrangement and the required, preferred lender requirements can be triggered simply by promoting loans. So keep that in mind as you're talking to students about different loan products. Oh, we have a poll question. So does your institution have a preferred lending arrangement? I'll give you guys some time to click and submit your answers.
And Abby, I'll jump in while we're waiting for answers and note that recently, as we've been looking at these issues more, as the CFPB and Department of Education have been paying more attention to them, we've noticed that we'll ask a number of schools, do you have a preferred lending arrangement? And their answer is absolutely not. But when we go to their websites and we dig a little deeper, we're not sure that the Department of Education or the CFPB would see their arrangements the same way. So if you're not sure, this may be a great time to check into the requirements and whether you're meeting them.
Yeah, Annie, it's exactly right. I've stumbled upon a number of websites that I'm thinking to myself, that might be a preferred lending arrangement, but it's all so fact specific. So keep that in mind as you're evaluating your compliance. Okay, we almost have 50%, so I'm going to go ahead and move it forward. About 15% say yes, almost 50% say no, and 40% say they're not sure. So something that sounds like we could all benefit to consider. Going forward, so some of the substantive requirements associated with preferred lending. Schools must have a code of conduct. The code of conduct must prohibit some of the things you see up here, like revenue sharing with lenders, contract benefits back to the school, basically any benefit from the lenders associated with securing loans or promoting loans or anything like that. So keep these in mind as you guys are drafting these codes of conduct. The code of conduct also should be published on your website. Preferred lender list. This is another thing that if you do have a preferred lender arrangement, you are required to have a preferred lender list. This is basically something that's published on your website that provides some information about the lenders that you are recommending. This next slide here has some of the requirements that the list must comply with. So basically it must disclose things like the interest rate, the terms and conditions of the loan, the reason behind participating in the preferred lender list. And I actually want to kind of talk about this one for a second. There's also a requirement to do at least some level of diligence on these loans. So schools should be asking lenders for things like their disclosures, whether or not they have the appropriate licenses, and evaluating whether or not these loans are actually beneficial to students before just blindly promoting loan products. Some of the other things that it should include is like method and criteria of selecting lenders. Typically, we will recommend if you are going to have a preferred lending arrangement to go through some sort of RFI process, where request for information, where you're asking lender these questions. And then you've established an internal policy or procedure associated with actually selecting or approving that this loan would be included on your list. Moving forward, duty of care and duty of loyalty. This goes back to just the obligation of doing some diligence, making sure you're acting in the best interest of the student. One way you could think about this is like, is this a loan that I would want my daughter or son to do? Obviously, it's going to be more complicated than that. But if you wouldn't recommend it to a family member, it might not be the best loan product out there. And then just taking a kind of a review of what else is offered on the market to make sure it's competitive. Co-branding prohibitions or limitations. This just talks about basically not making it sound like the school is making the loan, and just making sure that the marketing and advertisement of that product is complying with the federal requirements. And then self-certification form, we've already talked about this. The bottom line is that the school is probably going to have to help the student complete that. They can post the information online, but often we recommend that schools be available to help students complete the cost of attendance section. So alternatives to preferred lending arrangements. You can also have a historical list, which would basically just list every loan that you've received within a defined period of time. Often this goes back about 3 years. So these are the loans that have been offered to our students or are used by our students to pay for tuition over the last 3 years. A neutral list, that's going to be referring to a third-party neutral list that has compiled these lenders. You do need to be careful to make sure that that third party isn't receiving any sort of benefit from the lenders and making sure that they are truly neutral. Okay, our next topic, borrower defense to repayment and misrepresentation. This is a really hot topic right now, so we'll just dig right in. Basically, the BDR rules they went into effect July 1, the new ones, and they were quickly enjoined by a federal court, and that is currently pending. So the future of these rules is somewhat in the air, but I do think that there's going to be some iteration of this, if not the one that was in effect July 1. It establishes a federal standard for BDR claims. Before the new ones that were in effect in July, there were 3 different standards, and so it made it confusing which standard would apply. The new version of the rules also added a new section related to aggressive and deceptive recruitment, and it reinstates a ban on pre-dispute arbitration and class action waivers. So grounds for a BDR claim, it can include substantial misrepresentation, which can include misrepresenting things like the nature of an educational program, nature of financial charges, employability of grads, or omission of fact. Breach of contracts, substantial omission of fact, aggressive and deceptive recruitment, federal and state judgments, or adverse actions. With this new section related to aggressive and deceptive recruitment, there are several key points that were not previously in the BDR rules. Things like pressuring enrollment decisions, making same-day enrollment. Basically, if you make a same-day enrollment decision, that could be seen as really aggressive if you're starting to really require that or push on students to make those. Taking advantage of lack of knowledge. I think this is really targeting these first-generation students or students who may not have the most sophisticated background when it comes to financial products, or even just making decisions about which school to enroll in. And then just overall, just repeated unsolicited contacts. That's also a really hot one during negotiations. I think that they discussed what would this be? There was no hard and fast number established in the rule, but the VA says 3 unsolicited contacts could be aggressive. So maybe that's what that means. The bottom line is just making sure you have a process to unenroll students from the contact list if they've requested to not be contacted. Actually, before we move on to this slide, Annie has had some experience. Annie and I both have had some experience with this topic recently. And Annie, if you wouldn't mind chiming in and letting the audience know what we're seeing.
Sure. seems like every time I turn around in the office, we have another attorney who's working on assisting a school with a borrower defense to repayment claim. In mid-August, the Department of Education released a big batch of borrower defense notifications to mainly, I think, nonprofit institutions. And many of our schools have gotten a batch of borrower defense claims. Many of them are based on the bases for claims identified in the regulations that Abby's already talked about. Some of them are not. Some of them are based on things that aren't really covered by the borrower defense regulations. My favorite, it was a student who wanted her loans discharged, or still wants her loans discharged, because she didn't receive a paper copy of her diploma and therefore is experiencing emotional distress because she doesn't have it to hang on the wall. Now, regardless of whether you think that the claims you've received are meritorious or whether you think that they're covered by the borrower defense regulations, we do recommend that schools provide some response to the departments in order to preserve schools' rights, to make sure the department understands that we dispute these claims, and to put yourself in the best position possible should the department choose to grant the claim and then come to you in a recoupment action, or should the student come to you on some sort of litigation claim based on their allegations in their borrower defense application. We've been helping schools with this. We're happy to talk about it in more detail another time, but in short, we don't necessarily recommend a scorched earth response. It's not necessarily, depending on the nature of the claim, important that you call in everybody who might have the smallest piece of information about the student, but consider some response. We do recommend some investigation by the school, issuing a document hold, because now you're on notice that the student has said they have a claim against you for alleged misconduct, possibly notifying your insurer, and filing a response that denies both the specific allegations that the student may have raised in the claim and raising a number of objections and taking a few steps to help you preserve your rights to respond should the department grant this claim and it somehow comes back at you. And I will just flip to our last slide. I know we are right at time. This last slide highlights some considerations that kind of round out what we've been talking about so far. So not only do we have the CFPB and the Department of Education, we also have the FTC, Department of Defense, and VA that have similar rules around student financing and consumer finance in the area of higher ed. Keep in mind that being aware of these requirements and all the other ones we've talked about today, paired with this general idea that we should be transparent and fair with our students and our employees, can really help mitigate risks to your institutions and help your students and your employees feel like they've gotten a fair shake. So with that, and being right on time, I will hand it over to Leslie to close us out.
Thanks, Annie, and a great closing message for sure that sums up everything we talked about. So thanks everyone for joining us today, and we hope that the information was helpful to you and to your organization. As a quick reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We do use this feedback to plan future programs that are applicable to you and your needs. And this concludes our webinar. Thank you very much.